30-plus pages to read.
Did you inform
They will be
the jury?
informed of the law.
Did you inform them that they
Mr.
can nullify
Brooks?
the law?
Oh,
Mr.
he's talking
Brooks?
about nullification.
You do not have that right to request that.
Yeah.
And
Were
I'm
they
advising
informed?
you one more time, this
the
is your
judge won't report a
opportunity to
nullification
provide
to
your
the jury.
closing argument. Please begin.
I intend to. When ready, I just want to know if the jury was informed.
Was the jury
that they
here?
can nullify the law?
Mr.
they
Brooks,
are-
you
that
have
they
no
have
right
the
to
power.
make that argument to the jury.
Yeah, it's not considered
It's
relevant.
true. They have the power.
They do have the power,
All
but
right,
that's
I'm
not
going to
admissible.
excuse the jury.
Oh, wow, the
They
jury
should know
was
that
there
they
for
have
this.
the power.
Normally, these arguments
Please
take
rise
place
for the jury.
outside of the presence of the jury, because you don't want the jury overhearing conversations about nullification. So a couple of things on that. He's right to a certain extent. Jury nullification has been recognized as a power that exists that the jurors have in a criminal case, but it's not one that judges encourage or that you're ever able to tell a jury about. This is exactly what jury nullification is defined as. So jury nullification occurs when a jury or the jurors individually, when they decide to acquit a defendant in a criminal case, despite at the same time making factual findings that would lead to a conviction if they applied the facts that they found to the law as instructed by the judge. And the reason that jurors do this is typically because the result would be contrary to their sense of justice, morality, or fairness in a case. The reason that right exists is kind of a combination of two things in the law. The first is it's a combination of the fact that the prosecutor is unable to appeal an acquittal. So that means if you're acquitted of a crime, right, double jeopardy applies. The prosecutor can't appeal it to higher court and say, hey, something went wrong at trial, give me a new trial. That's not how it works. Once the jury comes back and says acquitted, that case is done. And the other part of it is this longstanding practice that we have in our American courts where jurors are free from scrutiny. So their deliberations are secret. Absent exceptional circumstances, they can't be called in to testify about their deliberations. So if a jury decides to acquit somebody based on this concept of jury nullification, them just disagreeing with the result, then there's no way to really ever find that out or to take any action against it if they come out and publicly say that's what happened. And a lot of our most famous cases are actually cases of jury nullification. So you think about some cases in media and popular culture. Time to Kill, right, is a super famous lawyer movie. That's the Matthew McConaughey one that Sam Jackson's character is brought to trial for murdering the man who murdered his daughter. And in the end, the jury acquits him. But there was no question the fact that he, committed first-degree murder in that case, or maybe heat of passion. But he's acquitted completely of all counts in that case. It's because the jury nullified. This comes up in Colorado cases. The most recent one would be a case called People v. Scott. It's a 2021 case from the Colorado Court of Appeals. Kind of similar to Mr. Brooks's case. In that case, it was a person who's pro se, meaning an individual without a lawyer. And he was brought to trial for a charge of intending to distribute controlled substances. And during his testimony, so while he was testifying in his own defense, he kind of went down this line where he was comparing his circumstances to individuals who were prosecuted under prohibition for selling alcohol, and tried to make an argument that was an unjust law and his law was unjust. And for that same reason, he should be acquitted. And the judge shut that down. And the Court of Appeals agreed. And what they found is that that argument to jury nullification is irrelevant. For evidence to be admissible in a criminal court, it has to be relevant, meaning that it has to make some fact in consequence more or less likely in the case. And so what the Court of Appeals found is that argument didn't make any of the facts in this case more or less likely, and so therefore it wasn't relevant or admissible, and it was contrary to what a court's supposed to do, which is encourage individuals to follow the law. It was also contrary to the oath that jurors take. So jurors take an oath when they are sworn in to well and truly try the case according to the facts and the law that they're given. And jury nullification is contrary to that, right? It's disregarding the law itself. It's also contrary to an instruction that jurors get when they are given the jury instructions right before they go back to deliberate. The judge reads them a whole list of jury instructions, and one of those jury instructions is that they are instructed to follow the law whether or not they agree with the law. So what the Court of Appeals said in that situation is that, look, we recognize that there's this de facto power that jurors have to nullify in a given case, but we're not going to encourage arguments about that to the jury. There's no constitutional right to present those arguments, and it's not relevant for anybody's individual case. It doesn't make any fact and consequence more or less likely. So in Mr. Brooks's case, the judge absolutely shut that down. Any lawyer is going to know that that's a prohibited argument and isn't going to get into that with the understanding that that's going to be shut down and potentially provoke a mistrial. It was actually really surprising to see in Darrell Brooks's case that while the judge is having this back and forth with Mr. Brooks's conversation, that the jury's still present for that. A lot of times, I think in any other instance, especially if it was an attorney making that argument, they would be absolutely chastised for bringing that up in front of the jury. Jurors are never allowed to be a part of really those discussions about the law. That's why jury instruction conferences, which are the conference that happens where they're discussing what jury instructions will go back to the jury, that's why those are done outside of the presence of the jury. So that's the overview on jury nullification. It is a big part of the American system. It's one of the reasons that the American system is my favorite system. We have a system of juries and not judges. The breakdown is that juries decide the facts, judges decide the law. But in the American system, something like jury nullification can exist that doesn't exist in the common law English system, where it's all a system of judges who are both deciding the law and the facts. This separation of powers between the two is a uniquely American trait. It's what makes our system of justice so special, but it's also something that the jury's never going to be explicitly told about in any criminal case.